So I think we're all here. It's great to see everyone. We're living in such unprecedented times. To be a bit cliche, we've all been saying the same things for over a year now. Who would think that we would be able, for those of us with services that were able to transition to online or to pivot so well, another overused word, that folks who are working in our shelters, who are essential workers, and the mix with our other colleagues who have been able to continue to provide the supports that we must to immigrant and refugees and other marginalized community members throughout this health emergency, while at the same time dealing with the other emergencies, right? We know that women, the pandemic is having a disproportionate impact on women and particularly on racialized communities and Indigenous communities. And so this is all the environment and the context in which we are working. But as employers, we also have legal obligations, and I am glad that you've all showed up this morning to hear from our friend and lawyer Barnan, John Kilpack. Before I begin, though, I want to acknowledge that I'm joining you from Toronto, the traditional territories of many nations, most recently the Mississaugas of the Credit. I think it's also important for us to know that the Treaty 13, is the treaty that guides the relationship between our governments and the Mississaugas of the Credit. A bit of housekeeping. We encourage you to write your questions in the chat or to put up your hand. Selena and I will be paying attention to your hand. I think, is there a hand sign that people can use to put up? I believe there is.
Yes, on the participants, I believe it should be there, but I'll check. I don't see it. Yeah, under participants, there's the raise a hand there.
Yeah, so I will be going through to make sure to see people's hands are up, and so we'll be keeping a speakers list. For those who are writing questions in the chat, thank you for demonstrating. So Deb, your hand is up. Helen Rector, thank you. Deb, you
sorry.
For others who are writing in the chat, Selena will be canvassing the chat and reading out your questions, so Jean-Kil can answer. We will have a short presentation from Jean-Kil, and then we will go to Q&A. We are recording the sessions for your colleagues who are unable to join us this morning. So your questions, both your verbalized question as well as your written questions, are important because they can learn, and because I'm sure people have very similar questions that you do. Okay. Time to introduce our speaker this morning, Jean-Kil Pack. Many of you have attended workshops with Jean-Kil. I think this is our third one, I believe, Jean-Kil, if I'm not mistaken. So you know that she's a Toronto labor and employment lawyer with over 12 years of expertise. Her many years exclusively representing employers gives her an edge in planning a winning strategy for her employee clients. That's a plug for you, Jean-Kil.
Thanks for that lovely introduction.
I know. Jean-Kil has received, I have to boast about you a bit more. Jean-Kil has received favorable decisions at the Ontario Superior Court, the Federal Court of Appeal, various labor arbitration boards, and including the Ontario Human Rights Tribunal. Jean-Kil, the floor is yours.
Thank you. Thank you for that introduction. So I know many of you here today have a lot of questions about what are your obligations going forward in view of the changing landscape, in particular with respect to the COVID-19 vaccines that are being rolled out. I know that many of you want to know, what are your obligations? Can you mandate it? What are the limitations on that? So we're going to go through that. I prefaced all of this today to say that there really is not a lot of case precedent out there dealing with these issues. So a lot of it, even legal experts have probably more questions than answers. And I think over time, as the vaccine is rolled out and as there are more health guidelines issued, I do think that we're probably going to have better insight into what will be permissible, what won't be permissible. So we're just trying to envision that today, contemplating the various issues. But because it's a changing landscape, what I say today may may very well, my view may change in weeks to come based on this rapidly changing landscape. So we'll probably have another one of these presentations in months to come to kind of check in and talk about the changes that are taking place and new guidelines and regulations that may be issued. So just logistically, I want to make sure that everyone can see my screen because I prepared a slide deck presentation and I'm going to share screen. So I want to make sure that everyone can see what I am seeing. Okay. Is everyone able to see the PowerPoint presentation deck?
Yes, we can.
Okay, perfect. So I'm just going to walk through some major points of law that I think would be of interest to the folks attending today. And we're going to get to your very specific questions. And as you have questions, we may save some of those questions to the end when we open it up for question and answer. So today's topic are, essentially vaccinations and employers' obligations. But further to that, we're going to cover off like the current state of the pandemic and current regulations that are in place. I want to provide an overview of the Occupational Health and Safety Act. We talked about it last time, but it's a good reminder in terms of this is sort of the boilerplate legislation that sets out your overarching obligations as an employer to your employees. We're going to talk about the COVID-19 vaccination, whether employers can mandate COVID vaccines for employees. Can an employer require proof of vaccination? What if we're still dealing with work refusals? And we also are going to talk about potential liabilities for employers. Can they be sued in connection with someone who may catch COVID-19 in the workplace? And we'll talk about the WSIB regime, okay? So in terms of the current state of the pandemic, when we last prepared these slides a few days ago, the number counts are very high. The government of Canada has described the threat level as being high. In Ontario, there's a total of 255,000 cases. That number's probably gone up since we've last prepared this, with 5,800 deaths, or just over that. And employers are, with this changing landscape, have to adapt and have to develop new policies and regulations to deal with this new normal. Now, in the province of Ontario, we know that we have a province-wide second state of emergency. There are stay-at-home orders in place, and with that, only essential services are allowed to remain open. I know that some of you here today may be a part of those organizations that are currently providing essential services. For the new restrictions that are currently in place, there are restrictions on outdoor gatherings that are limited to 5 people. Non-essential stores are limited to curbside pickup. Non-essential construction is closed. Stores are permitted to open if patrons arrive before arriving for curbside pickup. There are now restricted hours for retailers. There is no in-class instruction at schools until February 10th. We don't know if this is going to get extended. It might, depending on the number count. And what's important for most of you to know is that businesses must ensure that employees who can work remotely can do so. Face masks have to be worn on premises, and it's now recommended that individuals wear face masks out of doors in child care centers for non-school age children remain open at this time. So many of you just want to know, what are the employer's health and safety obligations to address COVID-19 in the workplace? Well, it's important for employers to be mindful of their overarching duties under the Occupational Health and Safety Act. So employers are responsible for taking every precaution reasonable in the circumstances for worker health and safety. That entails undertaking a risk assessment, including when to reopen, how to reopen, what policies and procedures that you need to have in place to ensure worker safety, ensuring that you have adequate PPE available as necessary. You have to monitor employee compliance. So it's not enough to just have a policy. You have to ensure that you're monitoring it. And you have to provide any necessary training so that employees know how to handle the health and safety routines to protect worker health and safety and reduce the risk of transmission in the workplace. And you have to inform employees about hazards in the workplace. So that may include informing employees when there is a potential risk of transmission in the workplace. So not all employers are going to have the same level of risk. Of course, this is going to vary by workplace. So it's not a one size fits all formula. So you're going to have to do a specific, when you're conducting your risk assessment, you really have to take into consideration a variety of factors that relate to your workplace, including the degree of traffic, the size of the workplace, the physical spacing. Can workers, can you ensure physical distancing? Are work from home options available? So that's going to very much vary based on the type of workplace, the type of service that you provide. The types of safety measures that can and should be deployed and employers should turn their mind to, and we've talked about this last time for those of you who did attend: physical distancing measures, protective supplies such as masks, hand sanitizers, that should be made available. There should be regular cleansing of common touch surfaces. Employers should generally include directional traffic like arrows, signs, etc., to limit employees from potentially not being able to physically distance. Implementing plexiglass barriers as appropriate. You should have screening for individuals who are on site, capacity restrictions as well to reduce the number of people and to ensure that physical distancing is complied with, and where possible, allow remote work from home arrangements. Now, in terms of conducting your hazard assessment, you should assess the layout, where are the touch surfaces, the frequency of workers coming into contact with others, designate areas according to risk level, low, medium, high, or very high level of transmission, and address accordingly. And generally, particularly those in unionized environments, union consultation or notification may be required, and you should ask for employee input to identify risk hazards in the workplace. Employers have to act on those hazard assessments. Post COVID-19 return to work, safety plans and policies, either have it in a conspicuous place in the workplace, put it on your website, make sure you're distributing that policy and procedure guideline to employees via email. It could be on your intranet. Make sure that it's well known and conspicuous and available for employees. And it should be reviewed and assessed, right? Because this is a changing landscape. You shouldn't just, wash your hands of it as soon as you have your policies and procedures in place. The threat level and the risk to employees may change, and as a result, you're going to have to potentially regularly review and assess where those policies and procedures need to be changed. And just a reminder, the Occupational Health and Safety Act does impose obligations for employees. So ensuring health and safety and protection for those in the workplace is a dual obligation for both employers and employees. So because this is a joint obligation, employees have to comply with health and safety measures. Employees must wear protective equipment as required, and employees have to report on workplace hazards. So for example, if they know that they are at risk of transmission, they should be reporting that. If they're diagnosed with they're COVID-19 positive, they should notify. There should be a policy that requires employees to notify the employer so that you can plan and address it accordingly and contain that potential threat. And there is some case law coming out of the arbitral context. So employers can discipline and potentially discharge employees if they fail to comply with health and safety protocol. And there is some case precedent for that. Now, in the labor arbitration context, we are seeing some cases dealing with COVID-19. Garda Security is one case that I want to mention. This is a recent decision by arbitrator Keller. This case involved Garda Security. So they provide security services at various sites, including residential condominiums, commercial sites, and at the airport. In this particular case, I think it was an employee who was a security guard working out of at the Toronto airport. The employer had communicated health and safety guidelines to its employees requiring that employees isolate. while waiting for COVID-19 test results. And this was consistent with public health guidelines that have been issued and widely distributed to the public. And this particular security guard, she said she was unaware of the policy. So she said, notwithstanding the fact that the employer had implemented this policy, she didn't know about it. So on April 6th, she received and obtained a COVID-19 test. She was waiting for the results. And on that same day, on April 6th, she reported to work. And even though she was waiting for COVID-19, her COVID-19 results, she thought it was okay to report to work because she had no symptoms. And she did not inform the employer that she was waiting for test results. She ultimately tested positive. And when the employer had learned that she tested positive and showed up for work, the employer had fired the employee for cause. The union challenged that, saying discharge was excessive and inappropriate in the circumstances. And ultimately, in this particular case, arbitrator Keller had upheld the discharge, and he had some pretty scathing remarks for the employee. And he did, just quoting from the decision, state that the actions of the griever were a clear violation of the employer's public health guidelines. Her claim of not feeling sick is absolutely irrelevant. She was required to isolate, as she knew, for the safety and health of others. She chose not to, thereby putting countless of others at risk of illness or death. So, employers are within their rights to impose disciplinary sanction and, where appropriate, discharge if employees are failing to comply with COVID-19 policies and procedures. Okay, it will depend on the circumstances, of course. Every case may be different, but there is case precedent for that. Now, turning to the vaccine. Now, the landscape is changing, and I know a number of you have a number of questions related to the COVID-19 vaccine, and if you can require employees to take that vaccine as a condition of continued employment, which we'll discuss. So where things stand as of today, Canada has approved the COVID-19 vaccines, deeming it safe and effective for distribution. And the list of authorized vaccines are the Pfizer COVID-19 vaccine, as well as the Moderna COVID-19 vaccine. And there is currently a J&J vaccine that's in trial. And these vaccines are generally reporting between 80 to 95% efficacy. And the J&J vaccine may be approved by spring. That's what they're estimating if things go well. And what they say about the J&J vaccine is that this particular one only requires one dose, unlike the Pfizer vaccine, which requires 2 doses. And there's even discussion of a pill form of vaccine. So there is evolution, there is progress, and it's all very promising. And the question is, and I think a lot of people, there's a lot of uncertainty around this in terms of when exactly it's going to be made available for the general public. It is being rolled out, but it's being rolled out in phases and based on priority and need. And after each vaccination, a proof of vaccination is being issued to each individual who obtains that vaccine. So the burning question, I think, today for many of you is, can employers mandate vaccines for employees? So there is precedent for mandatory vaccination, I will say, in the school context. So for example, the Immunization of Schools Pupils Act requires that students take vaccines, and there are certain lists of designated diseases for which students have to take the vaccine. But there are exemptions, and there are exemptions for religious grounds, and there are exemptions for medical grounds. And so children under that legislation seeking exemption for medical grounds have to provide a statement of medical exemption from a health practitioner, so a nurse or physician. If it's a religious exemption that they're seeking, they have to provide a commissioned statement of conscience or religious belief form. So they have to fill it out and have that commissioned. So with respect to employers, though, what does that really mean for you? I mean, there is some precedent in the educational context, but for employers, does that mean that you can mandate the vaccination? So I guess it may end up being moot if the province or health authorities require it, right? They're taking it out of the hands of the employers, and the health authorities may actually mandate it to the general public or by sector. There is suggestion that they're not going to require it, but they're strongly recommending it. And so in most workplaces, what do you do with that? So you probably can't force people to take the vaccine. We say that because, well, you can't really tell an individual what to do with their body. It's their body, it's their health decision. So you can't force individuals to take the vaccine, but you can probably require that if an individual is going to show up, if they're going to be on your premises, that they provide proof of vaccination. So you can probably require it as a condition of access to premises, with reasonable exception. And we'll talk about some of those exceptions. You know, if there are no safe alternatives, right? So you can probably require the vaccination as a condition of access to the premises if there are no safe alternatives. For example, wearing a mask or distancing may be a safe alternative if the virus risk is contained, right? So I think it's very much going to depend. And I know people don't like answers like, oh, it depends. You want a straight yes or no, but unfortunately, it's not a straight yes or no, and it's going to very much depend on the level of risk in the community. It's going to depend on what kind of arrangements can you make that are safe in the workplace, and what is the risk exposure to your employees. So it's going to depend on a variety of factors. So, you know, but that doesn't mean, you know, if somebody refuses to take the vaccine, does that mean you just have to accept it? I mean, you know, ultimately, if someone makes the decision about what they want to do with their body, it's their body, their choice. But you can make it a condition of access. And if they're refusing, can you fire them, right? And say, well, if you're not going to take the vaccine, we can't let you in the workplace. So we have no choice but to fire you. And I think, you know, it's going to depend on the reason for refusal. Why is the person refusing the vaccine? So you're going to have to determine that. And I think you should be asking that question. There may be lawful reasons, legitimate reasons why someone is refusing the vaccine. And these are protected reasons. For example, medical reasons. Now, there is some science right now in terms of the testing and the research about these vaccines that it may not necessarily be safe for everyone, right? So that someone may have a valid reason not to take the vaccine for medical reasons. For example, if they're immunocompromised and their health practitioner is indicating that it's not safe for them to take the vaccine. There's also some suggestion that some individuals, there may be catastrophic effect if they're allergic to the vaccine. And individuals may have objection based on religious grounds. And these are protected grounds for refusing the vaccine, meaning that you may not just be able to say, we're going to fire you, okay? These are reasons that will trigger an employer's duty to accommodate under the Ontario Human Rights Code. Okay, what does that mean? So employers have a reasonable duty to accommodate those with medical restrictions. Employers have a reasonable duty to accommodate those who have religious objection. And that reasonable accommodation obligation is to the point of undue hardship, okay? Undue hardship means that it would be very, very difficult, highly onerous for an employer to accommodate that individual. And typical undue hardship arguments that are advanced by an employer are if it would impose excessive cost to the employer, if accommodating them would put them in violation of certain regulations, like for example, COVID-19 health regulations that are in place by the province, or if there are health and safety risks associated with that accommodation request. Remember, when we talk about reasonable accommodation though, what does that mean? That means, is there a way to accommodate this individual in the workplace or in their position, right? So that could entail, well, if they can't come into work because they don't have the vaccine, can they be accommodated in terms of a work from home arrangement? Can they be accommodated in terms of wearing a mask? So could it be a, well, if you're not taking the vaccine, can we accommodate them in terms of, well, if they're, you know, deploying proper PPE, they're wearing a mask, implementing physical distancing routines, that may be a way to accommodate them. Perhaps an accommodation could be in the form of a modified work arrangement, whereby we're looking at modified shifts or hours in which they could work, or potentially an alternate work assignment. Okay, so there may be a variety of accommodations that, and you should be considering, short of just saying we cannot accommodate you, we have to let you go. The employer will have to canvass what reasonable accommodations can be made available to allow the person to perform the essential duties of the position, if that's possible, short of undue hardship. Okay, and if there is no practical way or reasonable way to accommodate them short of undue hardship, I should say, I think it would be difficult to assert undue hardship by saying, you know, we got to fire you. If it's possible to put the person on an unpaid leave of absence. I mean, ultimately, if they can't return to the workplace, then it may be the case, and there's no alternative work, and there's no alternative work arrangement that can be safe or practical in the circumstances. It could be the case that they may have to be placed on an unpaid leave of absence, okay, until such time as it may be possible to accommodate them into the workplace, okay, short of termination. And as part of the, like if an employee is making an accommodation request, just be aware that you can require adequate documentation substantiating their accommodation request. So for example, if it's for a health related reason, you can ask for medical, confirming the health restrictions in place that may prevent them or justify their refusal from taking the vaccine. In the case of a religious exemption, well, we've seen in the education context that they're just requiring individuals to fill out a form and swearing an affidavit to that effect. It may be reasonable in the circumstances to require that they provide, if it's a religious exemption, that they're seeking a letter from their church or organization, place of worship, that may be able to confirm or corroborate the nature of that religious exemption. That may be an acceptable way of verifying whether this is a valid request based on religious grounds. And I would say that employees generally have a duty to share that information if they're making those requests, because the duty to accommodate is a two-way street. So they should be indicating that, you know, if they need that accommodation to let you, make you aware of that need and the reasons why, and to provide adequate documentation to allow you to make a determination as to how it's best to accommodate the individual in the circumstances. Now, if it's not a code-related exemption, so for example, it's not related to health, it's not related to religious exemption, they're just saying, I don't want to, my body, you can't force me what to do, I'm not taking the vaccine. Now, that's not a code-related, you don't have a duty to accommodate that individual. So you can decide, okay, well, if you're not coming to work, then the employer can decide, well, we can terminate, we can part ways with the individual. Now, there may be certain restrictions around that if you're unionized, so you're going to have to follow your collective agreement and determine what requirements may have to be followed under your collective agreement. But for non-union employees, you can say, well, if you're not taking the vaccine, then we're going to have to terminate this relationship. Now, and this is where I expect there's going to be a lot of, potential legal claims from individuals who are being let go because they're not taking the vaccine, and the employer is saying, well, if you want to come to the premises and you want to be on site, we need you to take the vaccine. Now, is that going to be cause for termination? I guess it depends on whether the essential duties of the position need to be fulfilled at the workplace. So it may be hard to argue cause for termination if there could be a reasonable alternative work arrangement that can be put in place to allow the individual to fulfill the essential duties of the position. For example, if individuals have been working and fulfilling those essential duties while working from home, that that it may be difficult to say, well, we have cause to terminate here. So I'm on the fence. Some lawyers have said that, you know, they think it may be a valid reason to justify cause for termination. I'm of the view that you know, in many cases it may not be cause, particularly if they can be accommodated, even if it's not a code-related ground for requesting the accommodation. But if there are other ways to allow the individual to perform the essential duties of the position in a safe and reasonable manner, I'm not so sure that that cause would exist in the circumstances. And why does that matter to you as an employer? Well, if you don't have cause to terminate, then you're going to be obligated to provide the individual with a severance package. So you may be faced with situations where you're terminating and it may be a valid business reason or operational reason to terminate, but you may not have just cause at law, in which case you would have to provide the individual with a severance package. Okay. Now, one could argue maybe this is not cause for termination, but we could say this may be a frustration of contract. Now, frustration of contract is a legal concept whereby, you know, there are circumstances that were not originally contemplated by the parties when they, you know, entered into this employment relationship that we're now faced with that make the contract impossible to perform. Okay, so for example, nobody anticipated that there would be this global pandemic and a need for a vaccination in order to actually attend at the workplace and perform the duties of the workplace. So it may be the case, and it's yet to be seen, we don't have any case precedent on this. There may be a viable argument to say, well, it may not be cause because, you know, we've acknowledged we can't force the employee to take the vaccine against their will. But, you know, it could be a ground to say, well, we can't, this is beyond the contemplation of the parties and the contract is frustrated. Yes, you have a right to say, no, I'm not going to take the vaccine, but we have a right to say, well, we need to ensure that the health and safety of those in the workplace, and we require the vaccine as a condition of reattending at the workplace. And so there could be a valid basis for asserting frustration of contract in the circumstances. And why does that matter? It may be another alternative argument to say, we're not required to provide a severance package in the circumstances. So we're going to part ways. We're not going to provide you with a severance package because we're of the view that that the contract has been frustrated. Okay, so short of termination, I mean, there are other alternatives, and it may be the case that you don't want to terminate your employees. I mean, you may have a very good employee who you may want to come up with some alternative arrangement for the individual. Can they work from home? Can we, you know, for the time being until the threat level is contained and we don't see a need to have vaccination as a condition to be on premises, perhaps we can put them on an unpaid indefinite leave. Maybe we can put them on a modified work schedule or mandate that they're wearing PPE. Now, can you require proof of vaccination? So if somebody's saying that they're vaccinated, how do you know? So can you require that they provide adequate proof? And I'd say probably yes. You know, employees have just be mindful that employees have a right to personal privacy in connection with their health and the status of their health. But I think that is outweighed by the compelling need of the employer to verify, right? It may not be enough to just rely on someone say so. I think it would be duly diligent in the circumstances for employers to verify that vaccination, that they are in fact vaccinated and safe to be in the workplace. Proof of vaccination is already required in some situations, like in health education settings, so there is precedent for it. So what if you still have employees though who are refusing to return to work for fear of COVID-19? So, you know, I think the research is still unclear as to, well, if you're vaccinated, it's not 100% you know, foolproof. There can still be risk of COVID-19 transmission. And there is some suggestion that the status quo may be for some time that PPE and other measures still need to be put in place, notwithstanding the rollout of the vaccine. And you may still have a number of individuals who fear coming to work. Now, be mindful that there is a regulated mandated procedure when dealing with work refusals under the Occupational Health and Safety Act, and the reasonableness of a work refusal is likely to depend on a variety of factors, including the nature of the workplace, the employee's age, their health status, proximity to other workers, and the health measures that are in fact being implemented. And if a work refusal, I'm not going to take you through all the steps of the work refusal, I did go through that last time, but if a work refusal is placed, and if it's unresolved internally, this can result in having to notify the Ministry of Labor, and a Ministry of Labor inspector will visit on site. There has, I think in the earlier stages of the pandemic, some of these inspections, I think there were some telephone inquiries made, but it can result in an inspection on site. And if the Ministry of Labor inspector concludes that the working conditions are unlikely to endanger anyone, the worker is expected, and you can require that the worker return to work. And if the inspector, on the other hand, though, does conclude that work conditions are unsafe, then what will happen is the inspector will generally order the employer to institute necessary precautions to address the health and safety issue. At the early stages of the pandemic, when they were keeping stats, and there may still be stats on the number of work refusals and the percentage that are allowed, but many of these work refusals, there were a floodgate of calls and individuals concerned about the general risk of COVID-19 exposure, and most of these work refusals were in fact denied. And so they were told to go back to work. Now, what do you do if there is in fact COVID-19 exposure in the workplace? So there are in Toronto, the public health authorities instituted notification requirements. So at present, employers have to notify Toronto Public Health if 2 or more people test positive for COVID-19 within a 14-day interval within the workplace premises. So they also have to designate a point of contact internally within the workplace to liaise with the public health authorities and to institute those measures. So there has to be a point person and a designate to deal with those communications. And the employers are required to ensure that contact information is up to date and available, and you have to produce it upon request within 24 hours. And you have to cooperate with the health authorities with respect to any infection prevention and control procedures. You have to allow them on site and to support them in developing or implementing any necessary prevention and control measures. And the Ministry of Labor, be aware, must be notified if there's a WSIB claim that's been filed in relation to COVID-19. So when can employees be required to return to work? So if the workplace is safe, employers can require employees to return to work. Now there may be exemptions with respect to individuals who may need accommodation for health-related reasons. So you may still be faced with employees who have general fears. And there will probably be a percentage of your workplace where people are genuinely afraid, and they may fear catching it either on transit, catching it at work. They may fear that their coworkers may not have taken the vaccine and they may be at risk. So, but if the workplace is safe, the employer can require employees to return to work. Okay. And generally, to put employees at ease, you should be developing robust safety protocols and measures so that employees are generally feel more comfortable, and those should be communicated well in advance. So you can develop a comfort level so you can reduce the number of complaints or employees who are refusing work out of fear in relation to COVID-19 transmission.
Makes no sense to me.
I know many employers may be concerned about potential lawsuits if someone catches COVID-19 in the workplace. Now, whether an employer can be sued for COVID-19 exposure in connection with an employee, that's going to depend on whether you are part of the WSIB regime or not. So if you are covered by WSIB, this is for WSIB participating employers only, it's a no-fault system. So the WSIB insurance policy will kick in. They cannot sue you in court for negligence or any kind of damages in connection with COVID-19 exposure. It is a no-fault system, so employees are entitled to claim benefits if they've suffered from adverse health consequences associated with COVID-19. So that can include loss of earnings benefits, compensation for medical expenses, but benefits are not available if they're asymptomatic. So simply catching COVID-19 and they're asymptomatic, they will be denied any type of WSIB benefits in those circumstances. Now, so workers will be entitled to benefits if the nature of the worker's employment created a risk of contracting the disease to which the public at large is not normally exposed. And they will also determine, has the worker's COVID-19 condition been confirmed? So is there medical backing them up, confirming that they actually have COVID-19, or do their symptoms present in a manner that's consistent with COVID-19 exposure? And likely they would be relying on medical documentation to corroborate that. So when they're assessing the nature of the employment and whether there's heightened risks, so they're going to look at, was there in fact, there'll be some analysis in connection with whether there was COVID-19 spread or a contact source. So they may look at the proximity and timing in connection with one worker having it and other workers reporting having it. They may also look at the level of interaction with the public. So they'll make that assessment to determine, was it likely that they caught COVID-19 in the workplace. Employers not covered by WSIB can be faced with a possible legal claim in connection with COVID-19 exposure. But mere contact at work is not enough. They have an employee, in order to claim damages from an employer, will have to assert that it was COVID-19 exposure resulting from an employer's negligence in the circumstances. So at common law, employers have a duty of care for the protection and safety of their employees. So you have a duty of care for worker protection that exists in occupational health and safety legislation, and that also exists generally at common law. And where the employer fails to meet an acceptable standard of conduct, standard of care, reasonable in the circumstances, then they can be held liable in negligence for damages in connection with COVID-19 exposure. And that could be in relation to employees. And you probably have a duty of care to visitors on site as well. And so that's why it will be important for employers to be vigilant in connection with ensuring that you have robust health and safety measures in place for the protection of those who may be on site and potentially can come, may be at risk of COVID-19 transmission. We are already seeing some legal claims being advanced before the courts. So Diamond & Diamond has recently filed a class action lawsuit on behalf of victims who died due to what they describe as avoidable negligence. So they're focusing on the long-term care sector. It's a $500 million class action suit. They've named a number of parties, including the government and municipal bodies. So it remains to be seen whether it will be certified and whether this claim may be successful. But I expect that organizations may see more of this. Employers in these circumstances may be inquiring about the availability of insurance, insurance that may be available in connection with COVID-19 related claims. I actually don't know what insurance policies are out there right now as it relates to general liability insurance, but it may be Also an opportunity for employers to take a look at that, assess their coverage to potentially avoid being in a predicament as it may relate to legal claims that could be advanced in future in relation to COVID-19 exposure, whether it's an employee or a visitor on site. And so now I'm opening it up for questions. I imagine that a number of you have some questions that relate to that. So I'm going to open it up and I'm going to close. I can stop share here. So I can.
Thank you so much, Jean-Keel. I think you're the only one who can make legalese sound exciting and interesting.
I'm not so sure, but yeah, so I'm opening it up if anybody has any specific questions.
There's some great questions in the chat. Selena will read and I will continue to look for hands up. Selena?
Yep, so let's start with the first one that came from Fatima. How do we protect staff's confidentiality for positive COVID testing while ensuring other staff safety?
That's an excellent question. So I think generally it should be treated on a need to know basis. So when you're dealing with someone who has exposure, who's COVID-19 positive, you may have a duty to advise, and likely do have a duty to advise other employees about the risk of possible transmission. It may be unavoidable. It may be the nature of the workplace is such that you have to notify them in terms of who it is, but to the extent the identity of the person doesn't have to be revealed. Like, for example, if you say on this date, a worker in this area or on this floor tested positive without having to identify the person. So it's a balancing act. And I think to the extent you can deal with the contact tracing, notification of employees without naming the individual or identifying them, that should be the way to go. And if it's not possible, then you may just have to identify that individual. Health and safety is likely to prevail over privacy concerns.
Thank you. We have another question from Marcia. How does it make sense that employers cannot mandate staff to get vaccinated if the employer can mandate records of vaccination as access to the premises?
So that is, you can mandate. I think what an employer is going to be allowed to do is that they're going to require vaccination as a condition of attending on the premises. It's not necessarily you're mandating it as a condition of employment, because it's possible that there may be other ways to allow the individual to complete the essential duties of the job without being in the workplace. So can they work from home remotely, right? So I think you're going to be allowed. And this is, we don't have any clear answers. There's no legislation in place, right? So there's no law that says you have to mandate this for your workplace or you're not allowed to mandate it. There's nothing in place right now that says you can or you cannot. It's going to be a balancing act. I think employers are probably, because of the health and safety risks, the danger of COVID-19 transmission, I think that employers are going to be within their rights to probably require it as a condition of attending at the premises. And as part of implementing that, I think you can require that they provide proof of vaccination. If they say that they're vaccinated, okay, are you vaccinated? We're going to let you back on site. Okay, you're vaccinated. So you say you're vaccinated. Can you provide your proof of documentation? Can you provide the proof of vaccination so we can have it for our records? Now that also should be treated confidentially, right? So you're not gonna, I don't think it would be appropriate to have like some badge or something that you would require on site. It's probably, that too is also confidential. That's health information. So there has to be a discrete reporting mechanism or inquiry process whereby you're protecting the privacy of the individual involved. I hope that answers your question. I'm not sure that does, but.
All right, one more question from the chat. If the employer refuses to take the vaccine, does the employer have to provide accommodation? This question came from Sudeep Minas.
So that, yes, in certain circumstances. So if it's a religious ground that they're refusing, or if it's because of health-related reasons, those are two scenarios in which you're legally required to reasonably accommodate those refusals to the point of undue hardship. So if it's not a code-related reason, so if it's not health-related and it's not a religious objection, then you can impose, you can terminate the relationship. You may have to pay, you may not have cause for termination, but you can terminate the relationship if the individual is refusing the vaccine. So the duty to accommodate is only triggered if it's a code-related reason for the objection, health-related or religious exemption.
All right, we have another question from Janet Madume. There's been some controversial statements going around regarding the vaccine. Do you foresee lawsuits in the future from employees who feel they have been infringed on, that their privacy has been infringed on?
Privacy, so lawsuits pertaining to privacy, there is a tort, there is a tort for invasion of privacy. So that is a recognized actionable claim. Invasion of privacy it's not just any type of privacy, it's where you're intruding upon a sensitive information pertaining to the individual whereby, it could relate to their health information, or other sensitive information pertaining to the individual. So employers potentially could be liable if they're not safeguarding the privacy of individuals. There is a balancing act, of course, but at the end of the day, if one's privacy in relation to their health information is generally should be treated on a needs to know basis. I don't expect a lot of COVID-19 privacy related types of claims, to be honest. I mean, I think there are ways of managing that process. I don't think that there's a reasonable expectation of privacy necessarily associated with whether it may be obvious to individuals. If you haven't taken the vaccine, you may not be able to come on site, and other people may be able to put two and two together, but employers should generally be safeguarding that information. It's possible that they can be sued for invasion of privacy to the extent that they don't safeguard health information pertaining to employees. That includes their status in relation to vaccination. But I don't foresee a lot of legal claims arising from that, to be frank. It's possible.
There are two questions that I think you covered, Jean-Claude, but I'll ask them anyways. If the employee refuses to take a vaccination, does the employer have to provide accommodation? And if an employee refuses to take the vaccine, can the employer request a test to access the facilities? That's from Janet and Sinfard.
So can they ask for a test?
Can they ask for a test? If their employee refuses to take the vaccine, can the employer request a test if they want to access the facilities for work?
Okay, so COVID-19 test. Firstly, I think we've covered it in terms of, do you have to accommodate? If it's a code-related reason for the refusal, then you have to canvass potential reasonable accommodations for the individual to the point of undue hardship. Okay, so you're going to have to, if someone's refusing, the first step is to find out, why are they refusing? What is the basis for the refusal? And it could be just general, I'm afraid of the vaccine. I don't want to take the vaccine. It's my right. I'm an anti-vaxxer. Okay, that's fine. But you don't have to accommodate unless it's related to health reason or a religious exemption. Okay. So those are the two scenarios where you may have to set it aside. If they're refusing and they have they fall within those two grounds, we have to canvass, okay, this triggers our duty to accommodate. Are there reasonable accommodations that can be in place for the individual who's refusing for code-related reasons, and figure out whether there is some type of accommodation, whether it's work from home whether it's modified hours, whether if nothing can be done, maybe we put them on a leave of absence. Okay, if they cannot perform the duties because we require them on site, the nature of the work requires them on site, perhaps they have to be accommodated in terms of being placed on a leave of absence, and that could be indefinite. And it could be for a very long period of time until such time as they are ready to come to work. So short of, unless if they're outside those two scenarios, you don't have to accommodate. You can say, well, we're going to decide to terminate this relationship, or we're going to come up with other reasons. It's within your management right. The question will be, if you decide to terminate, are you going to be required to provide a severance package? I think that some lawyers are a little divided on that point. I think you probably would have to provide a severance package in that circumstance.
Yeah, and actually that question came from Sudeep. Sorry, Sudeep. And the other question was, if an employee is saying no to a vaccination, can the employer say, well, if you want to come back to work on the site, you must have a test done?
And that might be the reasonable accommodation that's put in place, right? So it depends on the efficacy of the testing and the validity of the testing. I mean, if it's on the spot testing showing present, because I'm not sure that all of the testing in place is readily available if it's rapid testing, and so I don't know all of the information and the current state of the market on that, but that could be one of the accommodations that you say, well, if you're going to refuse, we're going to require that you be tested to ensure that you're safe to be on site. I think that may be reasonable in the circumstances.
Yeah. Selena, I don't see any hands. Go ahead.
Okay. If this one is coming from St. Phal. If an employer mandates the vaccine and an employee gets sick after taking it, what are the liabilities for the employer?
Right. So when we say you're mandating the vaccine, you're not telling you have to take it as a condition of attending on the premises, right? Like if they're working from home, then it doesn't really matter if they take the vaccine or not. And if so, that's going to be their decision at the end of the day. If they decide to take the vaccine, can they hold you liable and say, well, it was economic duress. I needed to take the vaccine in order to work because I need to pay the bills. I need to get paid. I don't know that employers are going to be held liable for that. I suspect not, because I think the general standard will be expected that, and the best practice will be that individuals take the vaccine to curb the spread. It's the only reasonable way to get individuals back to work. And so I think it's unlikely. It's possible, but I think it's unlikely that an employer could be held liable for that. Because you could say, don't take the vaccine, we'll place you on a leave of absence, or don't take the vaccine, okay, we'll terminate. So they have options. It's up to the individual. They make that decision for themselves. They bear the consequences of their decisions, which may be that they lose their job, right? Short of individuals that need to be accommodated, right? But individuals that don't need to be accommodated, they have a choice. Nobody can force you to take the vaccine. An employer cannot force people to take the vaccine, but you can say, if you want to be on site, you got to take it. But I don't think that, and the individual will make their calculated decision at that point. Do I want to be back? Do I want to look for another job? You have the option of working for another job. So I don't think that will be enough to lay blame on an employer for liability if they ultimately do decide to take the vaccine, and unfortunately they may suffer the health risks associated with that. And because it's probably not going to be the employer's liability.
This question came from Vin. As a settlement agency, can we ask clients to show proof of vaccination and refuse to let them into our premises if they are not vaccinated?
I think it will be the same as for employees as for visitors, right? Like if you're going to be on site, you require confirmation that they've been vaccinated. Or this is also going to depend on the level of threat of the virus, right? Like I'm kind of talking about all of this in the context of there still being a viable threat of community spread, right? If the threat's contained, it may be that these types of policies are no longer required, right? We're talking about it in the context of there's still a viable threat of transmission in the community, and it's still not necessarily contained. But I think when you have, I think it would be reasonable for employers or organizations to require that visitors on site also provide proof of vaccination, or otherwise follow health and safety protocol, right? It depends on, again, what is the level of risk in your organization, and is it safe to have people who are unvaccinated in the workplace. But if you're mandating it, and I think it's reasonable to mandate it, while there's still a viable threat in the community, I think that would be true for visitors on site as well.
Sorry about that. Okay, the next question. How can an employer prove, what can we do if an employee says they took the vaccine but refuses to produce documentation citing privacy issues? Is that something that can be enforced?
I think an employer can require proof of the vaccination, just because you have to do your due diligence. You may have a lot of employees who just say, I've taken the vaccine. Now, there could end up being legislation or regulations in connection with what an employer may ask for, but in the absence of it, I think it's reasonable for an employer to require it as a condition of their return to work on the premises.
And this question comes from Kelly. Would you agree that proof of vaccination is receiving the full 2 doses under the current 2 approved types of vaccines? Or is it would proof of 1 vaccination be sufficient?
My understanding, it depends on what they're issuing, but my understanding is that for right now, because it's 2 doses, that they issue the documentation confirming a vaccination after the 2nd dose. But it could be that you get a document that indicates that you've only gotten the partial dose.
All right, we have another question from Maria. What if the government were to mandate the whole population to get vaccinated? Is that legal?
Well, yeah, I think I think you're getting into, I would say that's an excellent question, and that's sort of what we're grappling with in some ways right now. I mean, it would be easier for employers, right? It takes the decision-making out of the employer's hands. I don't think that the government can impose like just an entire population to get vaccinated. I doubt that they're going to go that route. I think there would be constitutionality concerns, right? You have the right to your bodily integrity and right to decide what to do with your body. I don't think the state can necessarily control what you do with your body. So I think there would be viable constitutional challenges in connection with a province-wide mandate requiring vaccination. They are strongly recommending it. They are urging the population to get it, and I think that's going to be the best practice. And I think the overwhelming majority, at the end of the day, the overwhelming majority of the population will probably get the vaccine. I think we're probably talking about a small percentage of the population where people are going to be objecting, and then there's a certain segment of the population who unfortunately can't take the vaccine, right? Because of it could be a health-related reason, or because of that religious exemption. So yeah, I think I answered that as a no. I don't think the state's going to be able to lawfully do that.
We see which side of the argument you will be on, Jean-Kil, as an intervener into a constitutional case at the Supreme Court. Cassie will be there beside you. There are other questions that I'm not sure belong here. So there is one from Jackie. Even though an employer asks employees to take the test when the employees refuse vaccination, do you think the assessment centers allow them to take the test now? I'm not sure. And there was a similar one from Patricia Cousins asking about long-term care homes and if folks who work there must be vaccinated as of today.
So I don't know what, so I don't know the specific sector rule or what the regulation is for long-term care homes right now, but I would expect that they're vaccinating their essential workers, right? And so most of the individuals are getting vaccinated. It may be a requirement for them to work on site, work with a vulnerable population. And therefore, if they're not taking the vaccine, they may be required to just take an emergency leave for the time being, or some type of leave of absence until such time as they it's safe for them to return to the workplace.
Yeah, and the other one was around the testing. Do you think the assessment center is allowed to take the test? Yeah, if you want a test, you can go out and get a test, can you? The general population? I don't recall actually in Ontario.
I believe you can. There's different types of tests. So there's tests that you can get. I think the turnaround though is 48 hours or 72 hours. Like I don't think it's an immediate. So it's unlikely. I mean, the technology may change, and that would make it a lot easier for employers down the road. You know, around policies, if you could just test people on entry and get a result immediately. I'm not aware of any technology that allows people to do that. That would allow people to return right away, right? Because you know the risk, you can contain the threat right away if that type of testing were made available for public consumption. But my understanding is that it's not, but you can order tests generally, but they're not, there's a lag period in terms of getting those results. I think you can pay a fee, like some places are offering $90, $100 per head for tests.
Here's an interesting question. If religion is an exemption for vaccination, is it then legal to refuse in-person service when client or employee is not vaccinated?
So is it the worker? So if they're objecting for religious grounds, can they refuse to have an in-person meeting with a client, for instance? Is that?
Yeah, I'm trying to see, is it legal to refuse in-person service when client or employee is not vaccinated? Yes. So can you?
Because they have a religious objection.
That's correct.
Okay, so this is where the accommodation analysis comes into place, right? So you may have a duty to assess how can we accommodate the individual? They have a legitimate right to potentially object, right? How could we accommodate that individual? It could be that they conduct meetings via Zoom, if that's a possible accommodation. So it could be that they're not attending on site, that there are various other ways to ensure their safety, remember, because you still have a safety obligation to those individuals that have objections. How do we ensure that they can, how do we accommodate them safely in the work environment? I think is going to be sort of part of that analysis. And it could be that they're working from home, they're working remotely, they conduct these types of meetings over Zoom as opposed to being in person. Until it's very clear that, there may be such a time that the threat level of the virus is so contained that you don't necessarily have to take those precautions anymore. It's safe. They've objected to having the vaccine, okay. But we don't think that there is a real or a safety risk here anymore at present because the virus level is contained. Because at some point in the future, it will hopefully be contained. And we don't have to worry about all of these, we don't have to worry about vaccinations, but by then we may have herd immunity, but we don't have to worry about further measures being taken. But for the time being, to the extent that the threat level exists, you're going to have to consider how do we reasonably accommodate these individuals who are objecting safely in the work environment, or possibly if they can't be in the work environment safely, then maybe they have to be accommodated at home or on a leave of absence.
Yeah. So Jerome, that was an answer to your question as well about employer preventing non-vaccinated employees from entering the workplace, as it is an employer's obligation to keep workplaces safe and healthy. And yes, John Keel in her presentation talked about ensuring that it's in workplace policies actually.
Right. And it may be that the workplace is such that, and the risk level is fairly low, that you can have somebody who's objected on religious grounds in the workplace, still having on-site meetings, wearing PPE or physical distancing, right? Those are measures that we've put in place to contain those threats. And those might be the measures, the extra precautions that you're taking for those individuals.
There's another question around employer liability, are there any employer liabilities around sharing public health information about vaccination with employees and connecting them to priority vaccination opportunities? Not making it mandatory, of course.
But is there a privacy? Is the question related to a privacy concern?
No, I think the question is related to if I facilitate my employee getting vaccinated, and something happens, do I have a liability as an employer?
I don't think so. I mean, there's going to be there's going to be such broad public information out there. People are going to understand and have a duty for themselves, right? To understand what the risks are associated when you're putting something in your body. And so, like, referring them to general health, public health guidelines, if you're just referring them to the government guidelines, which is what the broader community is relying upon, I don't see any risks associated with that. So pointing individuals to, but you got to be careful about what you're pointing them to, as long as it's a viable, credible, legitimate information source. And I would suggest that you're using the public health authority information that's being, readily available for people. The people have a responsibility to inform themselves as well, but I don't see any risk to the employer by pointing them to public health authority information.
Yeah, there's another question, and this is a good one. Once the vaccination, I'm assuming, becomes generally available, will employers be obligated to have a policy for availability of coverage? So for example, if the employee wants to go to be vaccinated during the workday, does that have to be paid time?
I don't think so. It's just like any other medical appointment. It depends on your policies, right? Like some employers will have policies pertaining to medical appointments, paid time off, but like if somebody wants to get vaccinated, great. And you maybe, now it depends on the availability of the vaccinations, right? And how they're being rolled out and how readily available it is. If there's limited availability and limited windows in which people need to get those vaccines, then I think it would be reasonable to accommodate time off. But to the extent that these vaccinations are going to be readily available to the broader community, I don't see any requirement or restriction on an employer to say, like, take it on your own time. But I think it's going to depend on that rollout. We don't really have the luxury of being able to have much control about when, how, and what circumstances we can take the vaccine right now. So I think it's going to depend on the circumstances, quite frankly. I guess I'll backtrack a little bit from that. I think it's.
Yeah, so that was a question from Alexis and Aisha.
The vaccines are going to be rolling out, and it would probably be, it would probably be reasonable to expect that the employers are going to be allowing individuals to obtain access to the vaccine. But once overall, I think it's readily available, I think employees will probably at some stage be able to get that on their own time.
Thank you. That was a question from Alexis, and Aisha had a similar question. So just to clarify, just if staff refuses to take the vaccine because of fear or personal choice, can the employer let them work from home if the work allows them to? Does the employer have the ground to terminate them if they so choose?
Right. So if it's personal choice, right, not related to code restrictions, you can decide what you want to do at that point. Right. It's up to you. Do you want to accommodate them from home? You can do that. Do you want to come up with some alternative safe arrangement, like modified hours? Maybe they come in the evenings when there's nobody around. Maybe they are working different shifts where they're maybe you're rotating shifts to limit the number of people, because there could still be, for a period of time, notwithstanding the presence of the vaccine, still various measures that are being taken to ensure the safety of employees in the workplace. But you don't have to automatically fire, but I think you have grounds to say we're going to part ways. You may, though, have to pay a severance package if you're going to terminate the employee. So if it's not a protected ground, you have a right to say, well, we think we're going to part ways here because we need people to be on site. If you're not going to be on site, then we're going to have to terminate. But they have a right to a package, right? The employer, just stepping back a bit, the employer has a legal right to terminate without cause. If it's a non-unionized environment, the employer has a legal right to terminate for any reason, as long as they're not contravening legislation, right? Like the Human Rights Code. So that's why we get into issues and questions around accommodation under the Human Rights Code as it may relate to health, so disability, medical restrictions, or religious grounds. So an employer generally has a broad ability to set policies for their workplace, but it has to be done in a way that's going to ensure worker health and safety and comply with the code. But you can terminate. You can decide if you're not going to take the vaccine, we're going to terminate. It's not illegal to do that, but you may have to pay the individual a severance package.
Thank you. I'm just reading as we're going through. Selena, do you want to take the next one? I was looking at Jennifer Hollis's. Let me go while Selena tries to find it. Would it be likely that once vaccines become so widely available that we would also then be closer to herd immunity and risk contained enough to not mandate? Actually saying everything now are basically controlled. And so then would we not necessarily need policy around any of this?
Yeah, that's absolutely true, right? You don't have to have a vaccine policy if the risk is so low. And it's as long as the employer is ensuring that there's safety, that workers are safe in the workplace, that you're taking every precaution reasonable. It may not necessarily be the case that you have to mandate it or that you have to take other, over time the measures may loosen. So I don't think this is going to be a forever situation. I think that at some point, hopefully, crossing our fingers, that this threat will be contained and that we don't have to really look at these sort of rigid policies that may impact really the normal ways of doing things. So yeah, I do think that you're going to be assessing the risk as it evolves, and your policies are going to change as a result of that.
Yeah. What if employers do not have vaccination policies and another employee or client catches COVID within the workplace? What's the liability for the employer?
Well, so the assessment is, so like if they're in the WSIB regime, then they can apply for WSIB. They get those benefits. It's a no-fault system. So to the extent you're concerned about liability of a lawsuit, right? You're not covered by WSIB. You don't have a vaccination policy. So the assessment will be, were you negligent? Is the employer has a common law duty of care for the protection of their workers. Okay, so the question will be, did you fail to exercise reasonable due diligence in the circumstances? So due diligence doesn't necessarily mean, it's not a one-size-fits-all formula. It doesn't mean it has to be, you have to mandate a vaccine policy. You can have other measures, but it has to be assessed by the level of risk in your workplace. Okay, so so there are other measures that you can put in place to ensure worker health and safety, possibly. For instance, the physical distancing, plexi guards, masks, temperature checks, health screening. So those are the types of measures that may be considered and may be appropriate for your workplace. Everyone's workplace is going to be different. So because it may be your standard of care is going to be different based on that. So you're going to be assessed based on whether or not you exercised reasonable precautions in the circumstances. Were you duly diligent? Did you exercise due diligence for the protection of your workers? And it's not necessarily so you're not necessarily liable if you were duly diligent otherwise. So it doesn't necessarily mean you're negligent because you didn't have a vaccine policy. If you were taking other reasonable precautions for worker health and safety.
Very, very good. Our last two questions, I think we'll be done with these last two. Can a medical condition for exemption include mental health illness?
For an exemption from COVID-19, a mental, well, I mean, a health related, that's an interesting question. It's, you know, so it has to be for health. So there have some health restrictions. I'm not seeing the link, right? That there has to be some link, I think, between the health restriction and the request for accommodation, right? So, and this is maybe a bad analogy, but there are circumstances whereby there is cases whereby an individual may have a drug addiction, and they say, well, you know, that drug addiction caused me to steal, and therefore, you know, there should be some latitude shown for me as in the circumstances, because this was no fault, it's because of my addiction. And you know, if there's no linkage, there's no correlation there. I'm not sure I see a correlation between alcoholism and, say, theft. So in this case, I don't see a linkage or correlation between the mental health restriction and the request for accommodation. I find that I don't see the linkage there that would necessarily entail or trigger that duty to accommodate. But perhaps I'd have to give that some more consideration, but I don't see it. There could be, I suppose one can suffer from severe anxiety or mental illness that may cloud their judgment. And so, and if the employer is aware of that may require that the employer accommodate in that circumstance, possibly, right? Because their anxiety level is so disproportionate, for instance, and so they can't take the vaccine. And so that could be a scenario possibly whereby you may have to figure out a way to potentially accommodate that person in the workplace safely. So that
the person was Maria was suggesting that if, for example, someone with an anxiety disorder not taking the vaccine because doing so would have OCD or bring on anxiety attacks.
I could see that. So yeah, fleshing that out, I could see that being a potential scenario in which the employer, being aware of that information, may have to figure out a way to accommodate that individual. So if they're suffering severe health implications based on the prospect of taking that vaccine, then perhaps, and there's valid medical documentation to corroborate that, because you can inquire and clarify what is the restriction here. And if they can't take the vaccine, then are there other ways to safely accommodate that person in the workplace?
Good. And our last question, we heard from the Ontario government that the current vaccines that we have may not address the new variants of COVID. Is the employer responsible to monitor these developments and adjust HR policies and actions accordingly?
I would say generally, yes. I mean, you have to understand what's going on in the community, the broader risk to your staff. So so I think employers will generally and should be doing this and designating someone within the organization to monitor what is happening. But you can't just say, okay, we have this vaccine policy, we're done, we can kind of close the book, we're safe, everybody back to work. You're going to have to continue to monitor what is the risk level to your staff. So I think I would say you'd be duly diligent to continue to stay abreast of those developments, but whether it's a new strain or otherwise.
Thank you. Thank you so much, John Keel. This has been a good, solid 90 minutes of good conversation, good information. I'm not sure if you can see that in the chat, folks have been saying thank you, that how important this information is and useful the information is. Selena, fantastic job as usual. John Keel will be in touch as this is developing. Thank you so much for spending this almost 2 hours with us.
My pleasure, anytime.
And thank you, OCASI member agencies, for always stepping up and asking the questions. Jocelyn has one comment before we go.
Sure.
Jocelyn, you can unmute yourself. Oh, no, you don't? Oh, you're doing thumbs up. Oh, okay.
The best ever.
Yeah, have a great. Yes, we will be sending out the slides to everyone who participated, and the recording will be posted on our YouTube channel. So stay tuned, and we'll probably grab some highlights from the presentation for our newsletter, Ocasi in the Field. Have a wonderful, wonderful Friday afternoon and a great weekend. Thank you, Jean-Kiel.
Thank you, everybody.
Thank you so much. Bye.
Thank you, everyone.
Binfard, nice to see you. Bonjour.